judgment in a matter of A.M.A. Child.
I hand down judgment in this case, neutral citation number 2021 EWCA Civ 998. At the end of the hearing in this case, the parties were told that we would allow the appeal and that we would provide our reasons in writing. This judgment comprises those reasons.
Appeal in a matter of Hughes and other, and Howell.
Yes, Mr. Howell.
Morning. I'm appealing against the bankruptcy order that was made on the 25th of March 2019, and this is the second appeal from the first appeal on the 27th of February last year. My grounds, obviously they're in the papers. The second appeal, I'm saying was done on the wrong basis. On the basis of what the judge said, he would have come to a different answer if he'd done it on the right basis.
If he'd done what?
If he'd done it on the right basis, judging by what he wrote in his judgment, he would have come to a different answer.
Right.
And when it comes to the judge that made the bankruptcy order, again, the judgment was made on, I'm saying, it was made on the wrong basis. And on the basis that it was made, which was that the unsecured debt was unknown and wouldn't be known for quite a long time. There wasn't a secured, an unsecured liquidated debt, so I don't see how a bankruptcy order could be made. But obviously I don't agree anyway that it was unknown because the creditor had produced evidence.
But the house wasn't sold for 2 years or so after ICC Judge Burton's judgment, was it?
The house was sold in January this year, yes.
This year?
Yeah.
I thought we were told March, but anyway, that doesn't matter.
Yeah. Obviously that, I know something about why that was. It was a lot to do with the pandemic. There were 3 buyers.
Yeah, but I mean the ICC judge's point was that until you had an offer and a contract, nobody really knew how much the house was going to sell for, because the executors had dropped the price by the time that it got before Judge Burton.
Yes, but what I'm saying is that and obviously I've got a lot of places to take the court to in the papers. I've prepared that. But what I'm saying is that it was agreed by everyone who's looked at it that the part of the debt, the larger part of the debt, was secured.
Yes.
And when you have security, what you do according to the Act is you estimate its value. You do it on a forced sale basis. This wasn't going to be a forced sale, which is a fair point. Therefore, it would take longer. So you obviously would downgrade what the executor was saying was they were hoping to sell it for some extent. In order to equate to that, there was some discussion in the hearing with Judge Burton as to what that ought to be. You could say that the creditor was saying it was 48,000. I was saying it was 51, 52. I thought my aunt's savings were more than had been stated in probate. But then you would say, well, what valuation would you use, to satisfy the requirements of the court? And you might say it was 42, or you might say it was 40, and then the debt, the unsecured debt, was 58 minus whatever that is, 42, 40, and that really divided the debt into 2 parts, as is provided for in Section 269, you then have to address the unsecured liquidated debt and deal with it. And to the extent that I was proposing deferring payment by 1 week, that I suppose counts as compounding. I'd done a similar thing in December, which was 3 months before. So I was simply saying that I wanted to pay that debt, that unsecured debt, within a week, and the rest would come in due course. As things turned out, it took much longer than anyone would have expected. There was something very strange happened with the first buyer. It seems like they might have lost their deposit. We haven't got to the bottom of that yet. And then the second one pulled out as soon as the first lockdown was announced. And the third one made an offer late summer last year and completed in January. But of course, that wouldn't be something that would be envisaged in March of 2019. You might envisage it would take 6 months, 9 months, 12 months, perhaps. You wouldn't think it would take 2 years. I don't think that's fair to say. But in any case, I mean, if that had the petition been dismissed, I imagine people would have become alerted to the possibility, maybe after the first sale fell through, maybe there was going to be a further shortfall, but by that time we might have got into assessing the cost of the petition. There was another cost order that needed to be assessed, might have lumped them all together, paid that, added a bit for the fact that the sale was taking longer. That's, in my view, that's how it should have gone. And the Judge Burton did not say, she didn't use the figure of 10,000 in her judgment. Doesn't appear in the judgment. And she also didn't say that there was any problem about relying on me to pay the sum that I was talking about paying. She didn't say, that was unreliable or speculative or unlikely to happen. She didn't say that. She was purely concerned about not knowing how much effectively the unsecured debt was, and not knowing how long it would take to find out. And I think that's the wrong basis, because that's not how you normally deal with secured debt.
Just say that again.
Where would I start?
You said that that's not how it's usually done. I mean, what she was looking for was to see that the security and the amount you were going to pay now added up to more than the total debt, right? And what you said to her, as I understand it, was, and we've got it written down, is that you would pay £10,000, and I'm just looking for it, but pay £10,000. If someone thought that it ought to be more than £10,000, then I would go along with that. But that wasn't a concrete offer, was it?
Yes, I would submit it was, because I wasn't in a position to say how much the debt needed to be reduced to in order to be regarded as secure. I had a view about it. I thought it could well be...
But it's up to you. It's up to you to make the offer that it would be unreasonable for the creditor to refuse. Well, and you didn't. You made an offer of £10,000, thinking that was enough. If you'd made an offer of £20,000, maybe it would have been enough. Maybe it would have been unreasonable to refuse if you could have shown that you could pay the £20,000 within 7 days. But that's just not what happened.
Well, what I said was, and I have mentioned it in my skeleton argument, is that I intended to, my offer was that such that I would be overpaying in all probability.
Yeah, but what you say is not the point. The point is whether it was an offer that the creditor would have been unreasonable to refuse. And the only ground on which you've been given permission to bring a second appeal is on the ground that the judge misunderstood the offer that you'd made.
Well, apparently he did, because he said it was fixed at £10,000.
But it was £10,000. It's not an offer to say, well, I might give more if somebody, anybody says I should. Because the offer is to be made by you. It's not up to them to make an offer.
Well, I mean, that would be to say that I've got to say it's for example, 15,000, and then the court says, no, it's not, it's 17. So your offer...
Yeah, but you're not... I mean, what I'm trying to get across to you, Mr. Howell, is you're not negotiating. You're making an offer which it would be under the legislation unreasonable. You know the language of the legislation.
Yes.
We can look at it under section 2713. The court may dismiss the petition if it's satisfied the debtor is able to pay all his debts, or is satisfied that the debtor has made an offer to secure or compound for a debt in respect of which the petition is presented. The acceptance of that offer would have required the dismissal of the petition, and that the offer has been unreasonably refused. Now, what you have to say to get home on this appeal is that the judge misunderstood that you'd offered, say, £20,000. That was enough, undoubtedly, to overtake, when added to the security, properly assessed, to overtake the debt, and it was unreasonable to refuse it. But you can't go that far because of what your offer was not in terms more than £10,000.
I did mention figures. I think 15,000 was a figure I also mentioned. But I'm not sure...
Where's the offer of 15,000? I've not...
You see, I'm not sure that the legislation, the 271, requires necessarily a quantified offer if it's logically qualified, so that it's the figure which is unsecured, given the requirements, the normal requirements.
But it must surely be an offer which is capable of being accepted.
Yes, and it was capable of being accepted, because the court, the creditor, of course, could say, well, that would need to be, we'd need to have a debt of no more than 40,000. Otherwise, you couldn't possibly regard it as being secured on the basis of this estate, or your portion of it. And then we all agreed that the debt plus interest was 58,000. So that would obviously require me to pay 18,000. And then the judge would have to make a decision according to the usual matrix of factors as to whether it would be any reasonable person would refuse paying 18,000 within a week. And bearing in mind that what has happened and what is going to happen if it remains as it is that it's going to take a lot longer because than it would have done, because the receiver has to do his part once he gets the distribution from the executor.
And where was the evidence that you would be able to honour the offer,
well,
as it was?
I had some money available, but it wasn't quite as much as 18,000. But the real evidence...
We had 5,000, I think, on the evidence.
It might have been somewhere around there, 5,000 or 6,000, yes. But the real evidence was that I'd been called upon to do that in December. I'd been called upon to pay 15,000 before the judge was prepared to establish the security arrangement. And I did that, I think, in less than 7 days. And I'd also been correct in predicting that there would be another 15,000 early in the new year. Not that that was in my hands, but it was information that I reported to the court, which was correct. So I think my submission is that a reasonable creditor, bearing in mind they'd be much worse off, they get a very much smaller amount than if, for example, this bankruptcy order was overturned today, they would get all their debt, and they would have done on the 25th of March.
Well, they wouldn't have done because, well, they would have got, if your offer had been accepted, they would still have had to wait for the sale of your aunt's house before they got anything out of that, and that's taken 2 years.
Well, we're looking, okay, I understand the court obviously has to take account of facts that have occurred since, but at that point in time it wasn't expected to take 2 years.
Well, maybe not, but once the creditor has established that there is a debt which you owe, the creditor is entitled to a petition unless you can show that the debt will be paid within a reasonable time.
Well, that's...
And you couldn't show that.
That's not my understanding of the law regarding secured debt. If you've got a property, especially if property is on the market as it was, the savings accounts had already been closed, there was some money in hand, there'd been an offer on the garage, so it was at a very advanced stage, and an offer was accepted shortly after the bankruptcy order was made. It's just that they seem to have got a difficulty about completing, which I did actually report to Mr. Justice Nugent.
Why should the creditor be concerned with any of that? You reporting people because something went wrong with the offer? I mean, it's not for a creditor to have to wait and follow the ups and downs of the sale of your aunt's house, surely.
Well, the court had already established part of the debt being secured. That had been done on the 20th of December. So the creditor had security for upwards of 40,000.
So your point is that once the creditor is secured for part of the debt, it doesn't matter how long it takes for that security to be realised.
No, it clearly does matter. I've read the case law, and there have been cases where there's shared ownership. There may be difficulties getting possession. It may be easier to get possession by the receiver in bankruptcy than it would be otherwise. I've seen those cases, but this was not a case like that. It was a vacant property already on the market. So it was satisfactory security without any sort of shortcomings. It only had to be established what it was safe to regard it as being the amount it secured. And other than that, the creditor could rest assured that they would get their money, as you do with security. It was a sort of average house, fairly recently built, right in the centre of Market Town, empty, nicely done inside. There were 3 offers on it. Would have been better if there'd only been one and they completed, but it wasn't a house that people were likely not to want to buy. So it was just a matter of deciding what figure could be regarded as being secured.
And I think you're slightly missing the point, if I may say so, Mr. Howell. I mean, there is only one point, really, before us, and that's whether the offer you made was more than £10,000, and if so, how much, and whether it was unreasonable for the creditor to refuse it. But at the moment, what I don't understand is where we see that greater offer. I just don't see it. I mean, I know you got permission to appeal from Lord Justice Neary, and I've looked very carefully at what he said, and if we look at it, he said the appellant maintains that Mr. Justice Birss took his offer to have been limited to £10,000 when that was not the case. On the face of it, that point may have substance. Mr. Justice Birss recorded that Judge Burton had approached the matter on the basis that the concrete offer being made by the appellant was to pay £10,000 to cover the shortfall, when the appellant appears to have expressed willingness to pay more, saying in submissions that if someone thought it ought to be more, then I would go along with that. And then the question that arises from that, well, where is the concrete offer to pay more? Just saying that they may ask for more and you might respond in a particular way is precisely hostile to the way the section works.
Well, what I'm saying is that the offer clearly was, in principle, more than 10,000. 10,000 was said to be in the region of 10,000, or that was. There are lots of things that I said which implied that I was prepared to offer more.
Yeah, but you've just made your point precisely. You've made the point I'm putting to you precisely. You said you were prepared to offer more, but this is about making offers, isn't it? It's not about an offer that you were prepared in the future to make. The question is whether you had made an offer. And as you yourself now say, you were prepared in the future to make an offer. Not good enough.
Perhaps I misspoke myself there. I wasn't talking about the future. What I meant was that my offer was not limited to 10,000. It wasn't about the future. And I think that's quite clear from where I said I was expecting to I was expecting to receive money back at the end of the process. And I said that, as has been said, that if it needed to be more, I think there might have been some other quote.
Did you want us to look at a particular
I'm just looking to see whether it would help.
passage?
Well, I mean, there's the supplementary bundle, page 22.
Yes.
F.
Page 22
Page 22, yes.
of supplementary.
Of the supplementary.
Is that the number at the bottom of the page?
Yes, it's the.
It's the transcript in the hearing before Mr. Justice Birss.
Yes, I suppose that's not the best thing to quote, is it? Since it's not the actual.
Well, the part in the transcript before Judge Burton is at page 231 in the supplementary bundle.
Yes, in fact, I have.
You say, at the moment I've got less than 5,000, but by the end of the week I'll have 10,000 in anticipation of that. Some of that may have to come back to me, but obviously that was the original concept, so I don't have a problem with that. And if someone thought it ought to be more than 10,000, then I would go along with that. But at the moment, it seems to me that 10,000 would be more than adequate. That's what you said.
Yes. That was 231. I've got 231 at B. That was further down 231, was it?
No, that's 231 at B, what my lord has just read.
Also, I noticed that the Judge Burton, just before delivering the judgment, asks the creditor whether they are refusing the offer.
Sorry, which page?
I'm just looking for it, but it's where it's in the transcript where it says judgment handed down. In other words, there is an authority which I'm...
Sorry, which we need, if you're making a point on the text,
Sorry,
we need to look at the page. We've looked at the part that talks about the 10,000. Now you're showing us something else. Page 239 is where it says see separate transcript for
That's
judgment.
right. It was just about 3 or 4 lines above that. So...
Well, hang on. We've got that at page 34.
239 at C.
But you say, so you know, that would be appropriate if it was an offer to pay an unsecured amount. Okay, very good. I'll just rise for a few minutes, give my judgment at 12:30. Where do you mean? Must be before that.
239, are we on page 239 of the supplementary?
No, we're on now page 34, 35. I mean, just if you are looking at page 34, you say at the top to Mr. Justice Birss, just before he rises, top of page 34B, it's been suggested there was something wrong with the offer because there was no certainty. And then you say certainty is not required, as I've already said. I won't labour that point. It's inherent in offering security, there's no certainty. In terms of whether it was an offer or not an offer, blah, I'm not someone who's been through loads of bankruptcy proceedings. So the offer could have been brokered, if you like, in a hearing. There's nothing wrong with that as far as I can see. So I don't think that's what you were meaning, is it?
No, what I was meaning was page 239.
Well, that's the other hearing before
That's
Judge
the hearing
Burton.
where the bankruptcy order was made, and it was just
239.
before.
Where on behalf of the creditors, it said that we're now 22 months on from the petition. And Judge Burton says, yes, and you no longer wish to accept the offer that was made.
That's right.
And it said, indeed, because we now have no, and that was effected by the order of Deputy Judge Schaefer. So that's as it were, the old offer. Yes, but the limited confidence that we've had in December is reduced to no confidence.
Well,
That's certainly not talking about an offer of £10,000 or more. It's
Well, I
talking
was
about the
wondering-
offer encapsulated in the order of Deputy Judge Schaefer.
well, I thought that myself when I read the transcript, but I wondered why the judge was not referring to the offer that was in front of her.
Well, I wonder whether what you said after she'd given judgment is what you're referring to. Because after she'd given judgment, you said, on the grounds of the definition of... You were asked what grounds you wanted to appeal on. And you said, on the grounds of the definition of security, and also my offer to top up to whatever extent is regarded reasonable within 7 days. So that seems to be what you thought you had said.
Yes, and I think I was only saying it in a different way at that point.
So can you show us where you did say that to her?
Well, I think it is that page 231.
231 now.
Yeah,
231B.
yeah, 231B is where it starts, and then it goes most of the way down the page.
Well, no, I don't think there are any other figures given on that page, are there?
There may not be. Unfortunately, I haven't got that page in front of me yet. I'm still trying to get it.
But I mean, you know, that doesn't really amount to a concrete offer to pay whatever was necessary, even if that was a satisfactory offer to make. What you're saying there is that you have offered £10,000 and you'd go along with more if somebody else suggested it, but that's not an offer.
Well, what I was offering was to pay the unsecured debt. I regarded the action, the order by Judge Schaffer to have created two debts.
I mean, it's easy for a debtor to offer to pay whatever is required. You know, you could have a debt of £1 million and come in and say, I'm going to pay £1 million. But if you've only got £5,000, it's hardly going to be unreasonable for the creditor to refuse that offer.
Well, I was
that's the
offering
case
to pay
there.
the unsecured debt. The creditor had suggested it was at least 10,000, the unsecured debt. I didn't sharply disagree with that.
I mean, you make it clear in your submission to Judge Burton that you're going to have £10,000 by the end of the week, right? So you might say, in your favour, you might say, well, I did show, or I did explain, whether I produced evidence at a different point, I explained I would have £10,000 but you never produced any evidence or even stated where you were going to get the rest from,
Well,
if there was a rest.
as I said, the Judge Burton did not say that she had misgivings about whether I would pay that
Well, it's
sum.
not to do with whether she had misgivings, it's whether the creditor was unreasonable not to accept an offer you made. Anyway, we're probably going round in circles, but the only bit you wanted us to look at is the bit we are looking at page 231, is that right?
Yes. I mean, it sounds as though the court has accepted a lot of the other points that I was going to take the court to, unless I'm misunderstanding. Is it accepted that there were two debts, a secure debt and an unsecured debt?
Well, nothing is accepted, but we're addressing the only ground on which you were given permission to appeal.
Could I just list the headings that I was going to take the court to and see if any of them would be of help? I was going to make a point about the procedural background, but that's a very minor point, especially regarding what we're discussing at the moment. Again, another point about the debt and interest, but I think we're clear what that was. I was going to take the court to how the security was established in December. Where in the proceedings.
That's in Deputy Judge Shaffer's order.
Yes, there are various points.
You gave instructions to the executors to pay your share of your aunt's residuary estate to Mr. and Mrs. Hughes solicitors, and you gave them authority to accept it. You understand that?
Yes, and several times Judge Schaffer said that he wanted to secure the debt against the inheritance. So if the court, it wouldn't be helpful to go through that if that's understood.
Well, it secured part of the debt, didn't
Yes,
secure the whole
absolutely.
debt.
It seemed like it was more at the time in December, but
Well, you told, I think your evidence was, you were entitled to a quarter of your aunt's residuary estate. In fact, you were only entitled to a fifth.
we're 4 children, and I hadn't realised, I hadn't seen the will at that point. I saw the will just after Christmas. My mother was, I'm glad she was, because she gets care workers going in all day long, and it costs a lot of money. So, but I didn't know that. I think actually it said in the letter, divided by 4. I mean, the court had that letter, which was, I think, the first letter.
The executor's letter, yes.
Yes, the very first one. The next thing I was going to go take the court to was the estimated value of the security, which is component parts, what was thought the house would fetch, what was thought the garage would fetch, what the savings were. But again, if those are accepted as being...
Well, you gave various figures, but by the time it got to Judge Burton, the executors had said there was no interest at, was it 230,000? They dropped the price to 215, and there was another 16 for the garage.
That's right. And the savings, they said, were 90,000. They'd kept back, they distributed 75, and they'd kept back 15. But in the probate, grant of probate, which I have a copy of here, it says 100,000. So I was a bit confused about that. It doesn't make much difference, a couple of thousand. So the next thing was how the offer was put. Now, we are discussing that. I'll just see if there's anything else. I think what I've got is the page 231 that we've been talking about. And I've referred also, I was going to take the court to my skeleton for that hearing.
Which page is your skeleton for
well,
that hearing?
It's at 61.
Supplemental?
Yes. Doesn't really help us very
Paragraph.
much. Paragraph 5 is what I was referring to.
So you said in March 2019 that the exchange of contracts was only 6 to 8 weeks off.
Yes, well, that's what the executor said.
Well, that was your case, but obviously, sadly wrong by nearly 2 years.
When you
You told us
estimate the
this
value
morning.
of security, surely you take best information at the time.
I don't think, with respect, Mr. Howell, the executors did say that. They said they couldn't say when a sale might be agreed, but it was 6 to 8 weeks after the sale agreed that there would be completion and a distribution 4 weeks after that. They didn't say a sale was going to take place within 6 to 8 weeks.
But of course, nothing they said was a prediction, but they did say that they were hoping, and of course hoping is a lot different from anything else.
Yes, but the statement that exchange of contracts can only be 6 to 8 weeks off is nothing that the executors said. That's your assertion.
Well, what they said was that they were hoping for an offer within a month, and that it would take 2 further months to exchange contracts.
I mean, all that is slightly academic now. The reason you're showing us this paragraph 5 is in relation to the offer you made, and the only relevant sentence in this paragraph is the words, quote, neither the value of the estate nor D's ability to make up the modest shortfall that could arise has not changed, close quote. And those words do not obviously constitute an offer. Those words simply say that you are asserting that you have the ability to make up the shortfall.
Yes, that I was offering to pay the unsecured portion of the debt, and so it was an in principle statement. Could I take the court to page 22 of the supplemental bundle?
Page 22. Yes,
At F,
yes.
some of it may have to come back to me.
22F,
22F.
that's just repeating what we've seen in the transcript in front of
I
Judge
think
Burton.
it is, yes. I've also noted page 12 at G. I think in that hearing we were quoted from the transcript. Page 12 at G.
Again, that's the repeat of the transcript that we've got from Judge Burton.
Yes, it's the phrase more than adequate. The
Yeah.
intention was to pay a sum that was more than adequate to ensure that the...
No, Mr. Howell. You said, there's the bit where you said if somebody said it was more than 10,000, I'll go along with that. But you said it seemed to you that 10,000 was more than adequate.
Oh, yes.
You reiterated the limit of the 10,000.
Well, I stated my personal view, but I also made it clear that the principle was to cover the unsecured debt. And I'm not sure that the Act says that it has to be a numerical offer, as long as it's understood roughly what range you're in, that it has to cover the unsecured debt.
A reasonable creditor would like to know where the money's coming from, wouldn't he?
Well, they already saw, they've recently had 34,000 or 29,500.
Well, that may be, but where's the extra going to come from?
Well, I said I had some, and
You said you had 10,000. We said you would have 10,000 by the end of the week.
yes, but I'd already admitted that I borrowed part of what I paid in December from my oldest son. And if I had to, I would have done the same again.
I mean, the real point, Mr. Howell, is that we have to evaluate the materials that you've already shown us. And we have to evaluate what you said to Judge Burton and what was in your skeleton argument, Judge Burton, and then we have to look at what she decided and look at how Justice Birss decided the appeal to see if there is an error in the one area that you were given permission to appeal. And I think your point, if I may say so, clearly made, is that whatever words precisely you used, it was sufficient to convey to the creditor that you would make up the shortfall, and you say that is how it should properly have been understood by the judge, by Judge Burton, and by Mr. Justice Birss, and had that been properly understood, the judge would have decided, or should have decided, that it would have been unreasonable for the creditor to refuse that offer to make up the shortfall. And that's the way you put it. You've heard the court raising certain doubts about it, but I think it's perfectly clear that it's understood that's the way you put your appeal.
Yes, in the proceedings before judgment, it struck me then, and reading it again, it still does, that when I talked about paying the shortfall or the amount that left a secured debt remaining, I didn't understand why Judge Burton didn't engage with that.
Well, to be fair to you, Mr. Howell, when Judge Burton had given her judgment, you raised this point immediately as the ground on which you wished to appeal. And when Mr. Justice Birss gave his judgment, you did the same. I mean, not in the same words, but the same substance. And so I do think it can fairly be said that you have made this point all along.
Yeah.
The question only is whether, as a proper construction of the facts and on the applicable law, you're right. And that's for us to decide.
Can I say, thank you, my lord, can I say that I understood Mr. Justice Birss, as he was then, saying that what the offer was what was written in the letter a week or two before by me, and that's what Judge Burton was entitled to take the offer to be. But Judge Burton didn't do that because she didn't say it's 10,000 anywhere. And the other thing is that I was referring to, and I am confused as this
Lord Justice Coulson.
Sorry, I don't know how to address my name, but I'm just as confused as you were. Well, I suspect you weren't confused. You were quite sure that that she was referring to the December offer, although I don't know why she would have been referring to the December offer at that particular stage, when what was on the table was me paying some money in 7 days.
Right. Well, in a sense, whether that is the case or not doesn't affect the point that I've put to you and that you've put to us, and that it is the one that you say undermines Mr. Justice Birss's refusal to allow the appeal. So if you were right, then the appeal would have to be allowed.
Yeah.
And I'm not sure that whether there was confusion before Judge Burton actually matters.
Right.
Because, I mean, we have seen what you precisely, the words you said to
This is
Judge
what I meant by saying that Birss was looking at it in the wrong way, because what seemed to matter to me was what she was considering and how she determined it. And if he was wrong about that, then the question is, what was
If who was wrong about that?
if
Judge
Justice
Birss.
was,
Well, of course, if he was wrong
yeah.
about what she was considering and there had been an offer to her, you're right to draw our attention to the fact that it is the offer that was before Judge Burton that is important.
Yeah.
And as I understand it, I understand that, and I'm sure my lords do.
Can I say, regarding having sort of muddied the water about how to interpret the offer that she was talking about just before she handed down judgment. She clearly had my proposal in front of her, which was to allow me 7 days to pay a sum of money, which was, I don't see how she could not understand that that left the secured debt.
She understood that part of the debt was secured. That's the basis on which she...
But my intention was to leave only that part. It doesn't seem probable that she didn't understand that. Her problem was, how long would that security take to liquidate?
And if you go for a moment to page 75 in the supplemental bundle, you'll see the point on which Mr. Justice Nugent gave you permission to appeal against Judge Burton.
Yes.
What he said was that what you wanted to argue is that where part of a debt is secured, it doesn't need to be realised within a reasonable time because the creditor has security. And he went on to say that what the judge, that is Judge Burton, should have done is to accept that the bulk of the petitioning creditor's debt was secured and then consider whether, quote, the offer to pay £10,000 within a matter of days, unquote, was an offer that could not reasonably be refused. That was the point on which you got permission to appeal to Mr. Justice Birss. You didn't get permission to appeal on the basis that you'd made a larger offer than £10,000.
Well, he did say in the next line, didn't he? Or as Mr. Howell said, it could be...
Or as he suggested in the course of his submissions, if anybody said it should be slightly larger amount.
And Lord Justice Newey fixed on that point.
Well, it may be the same point on both appeals. And I think it is the same point on both appeals. You had said what you said. That was rejected by Judge Burton. You appealed to Mr. Justice Birss, and it was rejected by Mr. Justice Birss, and you said, with the support of Lord Justice Newey, that was an arguable point. But we have to decide whether that's right.
Can I make 2 other points that might help?
Yes.
One is that just before concluding, Judge Burton said that she had to, in her judgment, I beg your pardon, in her judgment she said that she had to make a decision or exercise discretion under 281. Sorry, I've got the numbers not all up in my head. Anyway, the one we're talking about.
271.
271. And she quoted one of the leading cases, but she didn't really exercise any discretion on that at all on that basis. She just said it, but she didn't then have regard to the points that one normally has regard to. She simply had regard to the time it would take to liquidate the security. So she was treating it not like security, even though she conceded that it was security.
Well, I mean, so that's whether it is or is not really the matter before us. The matter before us is the one we have now mentioned several times and been around the house about, and it's either right or wrong, and we've got to decide.
Yes.
And if it's right, then obviously Lord Justice Newey would not have given permission to appeal if it didn't matter. It does matter.
Understood. So I don't need to prove it matters. The other point I wanted to make was that there's some sort of debate, if you like, as to whether an offer can be made at a hearing, and I did see the authority of Timothy Lloyd QC in Rea Debtor 1994, which makes it clear that an offer can be made right up to the point where the order is made and determine whether it's been accepted or rejected. That's in the authorities tab 4, 909H.
Well, for my part, I don't need much persuading about that.
No.
If it's an offer, it's an offer. Might have to be an adjournment for the offer to be considered, but an offer.
Right at the bottom of the page, it says the position at the date of the hearing on the basis that, at least in this case, the offer was kept open until the hearing. Then it goes over the page.
Sorry, which page?
I'm
Did you
on
say
the very
909H?
bottom of 909.
Yeah, no, I've got it.
Going over to the top.
Yes.
So although I did only use the figure in my letter of 10,000, although I think I did indicate that it was in the region of rather than something precise, the discussion in the hearing was what was decisive about whether there were several opportunities.
Well, there is a sort of assumption that if you had made an offer at the hearing and it had been refused, when the creditor was represented sitting there in the shape and person of Mr. Brown, if it had been unreasonably refused, that would have come within the section. So I don't think that's the point. I mean, I keep on saying it, Mr. Howell. You've made very clearly your point, which is that the offer was enough and it should have been accepted, and it wasn't.
Well, my point is that what I would ask the court, I would have hoped the court did then on the 25th of March 2019, what I would ask the court now to do is to consider whether any other reasonable offer would not, reasonable creditor would not simply refuse, but would instead, I think all reasonable creditors would instead say, well, that would be okay if it was 18,000, and then ask the judge to exercise their discretion on that basis.
Well, we're not dealing with an offer of 18,000. So.
Well, in other words, if someone is wanting their money rather than to get a bankruptcy order, they would say, this debtor is saying that they're going to pay the unsecured amount. They've suggested that the unsecured amount is 10,000. They've also suggested it could be more. They've suggested that that doesn't matter because the instructions allow for the money to come back. And the question is how much is required in order to leave only the secured amount. So it's a qualitative offer with an indication of the sort of numbers that we're talking about. Yeah. And a creditor who wanted their money, quite a substantial sum now, and the rest secure in a property, then they would say, okay, well, we think it ought to be, you have to have a margin of safety, 15,000, 18,000, whatever, if they wanted their money. The way it is at the moment, they're going to share the money with a lot of other people, and it's going to take a lot longer because
Well, unfortunately, Mr. Howell, that's one of the functions of bankruptcy with which we're very familiar in this court.
Yeah.
So I don't think really that sort of takes the matter further.
Well, all I'm saying is that a qualitative offer, I don't think, is outside of the scope of 271.
No, I mean, you've made that point.
Yeah. I'm sorry to keep repeating.
No, it's all right, but, we've given you, if I may say so, quite a lot of time to make the point, and the point has been made, and we've understood it.
Can I just see if there's anything else that I should take the court to?
Yes, by all means.
I mean, we've talked about the length of realisation, and I only relied on, in the hearing, on what was said by the executor, which I think is very clear about. We hope to have an offer within next month, completion after a further 2 months, distribution a month after that. I don't understand why, if the executor said that distribution would be a month after that, he's taken 5 months so far to do that distribution. He said something about council tax and that there'd be some refund or something. That's That's what he said to my brother. So things have gone very badly wrong all along the process. There's been, there's no point in going through that because it's not pertinent. But he said categorically in a letter, he said those things which I quoted in there at page 233 and also at 339. But I think we already understand that. And I was going to go into the amount of the unsecured debt, which is what we have been talking about. I refer to section 269, which says that the petition should, if the creditor holds security, contain an estimate of its value. And as I said earlier, on a forced sale basis. But the Act does not preclude the estimate being varied, and in fact the rules provide for that. 6.115, I think it is, provides for an application to vary the estimate of the value of the security. And also, of course, the creditor can give up their security, and the rules provide for that as well. I think it's 109, 6.109. So the point being that the focus of the court, I would have expected to be on whether something in the region of 10,000 was consistent with the valuation which the Act required, or whether, as I now think, it should have been slightly more, but I didn't concede that in the hearing. And that a qualitative offer which said that it was the unsecured part on the basis of the Act, an estimate, for sale basis, was what my offer was.
Right.
Let's see if there's anything else. The point I made at the beginning about if the judge thought that there was no knowledge of what the unsecured amount was, then it was not a liquidated debt, and that a bankruptcy. There is a case which does not bind this court by a deputy judge, waive lending, which I didn't put in the bundle, but just because the unsecured amount was not specified, the order was the bankruptcy order was set aside. That was Martin Griffiths, QC, who I believe is a High Court judge now. So I think that's why I said the Burton seemed to be approaching it on the wrong basis, being concerned about the time to liquidate, unless of course it was a very extreme case where it might go on for 10 years or something. And also saying that it wasn't known how much was required to.
I think we're really going off the point. We've identified the point, and you've made your submissions on it. Do you want to make any more submissions on the point?
No, I think I've made all the points I can.
Well, thank you very much, Mr. Howell. We'll just rise for a minute or two.
Rise. others to do. Yes, first they come back. Yeah, they're coming back. But if they may finish, I don't know. All rise.
Mr. Brown, we don't need to call on your submissions. Thank you very much. I will invite Lord Justice Lewison to give the first judgment.
On the 10th of September 2015, Deputy District Judge Revere gave judgment in favour of Mr. and Mrs. Hughes against Mr. Howell for the sum of £47,131.01, arrears of rent and contractual interest, and ordered him to pay their costs, summarily assessed at £26,000. Mr. Howell did not pay the judgment sum. Mr. and Mrs. Hughes issued a bankruptcy petition in May 2017. The petition was adjourned several times, notably on the 11th of December 2018, to allow Mr. Howell to pay part and secure the balance. By March 2019, Mr. Howell had paid £29,500 towards the outstanding sum, but the remainder remained unpaid. On the 25th of March 2019, ICC Judge Burton made a bankruptcy order. Mr. Howell's principal complaint about that order is that the judge should have accepted his evidence that he would be in a position to make a payment reducing the outstanding balance within a short time, and that once that offer of payment had been accepted, the balance of the debt would have been adequately secured. Mr. Justice Birss dismissed an appeal against that order, but Lord Justice Newey granted permission for this second appeal. Section 271 of the Insolvency Act 1986 provides, quote, 1. The court shall not make a bankruptcy order on a creditor's petition unless it is satisfied that the debt, or one of the debts, in respect of which the petition was presented, is either a debt which, having been payable at the date of the petition, or having since become payable, has been neither paid nor secured or compounded for, or b, a debt which the debtor has no reasonable prospect of being able to pay when it falls due. 3. The court may dismiss the petition if it is satisfied that the debtor is able to pay all his debts, or is satisfied a, that the debtor has made an offer to secure or compound for a debt in respect of which the petition is presented, b, that the acceptance of that offer would have required the dismissal of the petition, and c, that the offer has been unreasonably refused. And in determining for the purposes of this subsection whether the debtor is able to pay all his debts, the court shall take into account his contingent and prospective liabilities, unquote. Section 383, subsection 2 provides, quote, a debt is secured for the purposes of this group of parts to the extent that the person to whom the debt is owed holds any security for the debt, whether a mortgage, charge, lien, or other security, over any property of the person by whom the debt is owed, unquote. In Secon, S-E-K-H-O-N, and Edgington, 2015 EWCA Civ 816, 2015 1 WLR 4435, I said, in a judgment with which Lord Dyson MR and Underhill LJ agreed, quote, 18, the starting point is that if the petitioning creditor establishes that the statutory conditions are fulfilled, he is prima facie entitled to a bankruptcy order, 19, the court, of course, has the power to adjourn the petition, but the practice is to do so only if there is credible evidence that there is a reasonable prospect that the petition debt will be paid within a reasonable time, unquote. I also pointed out that if the debtor does not produce any evidence of his ability to pay, he takes the risk that the court will not accept his bare assertion as to his means and ability to pay. At 26, I said that this court should not cast any doubt on the validity of that long-standing practice. A number of cases have considered the approach to be taken where it is asserted that a creditor has unreasonably refused an offer to secure a debt in respect of which a petition is presented. HMRC and Garwood, 2012 BPIR 575, Chief Registrar Baster reviewed all the relevant authorities and drew from them the following principles. In the quotation, I omit references to authorities. Quote, 1. The starting point is to ask whether a reasonable hypothetical creditor in the position of the petitioning creditor would accept or refuse the offer, bearing in mind, however, that there could be a range of reasonable positions which such a creditor could adopt. 2. The test is objective. 3. It is necessary to consider the extent to which the reasonable hypothetical creditor may be taken to have the characteristics of the petitioning creditor. 4. The court must look at the position at the date of the hearing. 5. The court is not limited to considering the matters taken into account by the petitioning creditor when the offer of security was refused. It must look at all the relevant factors and their impact on the reasonable hypothetical creditor. 6. That includes the history. 7. The debtor must be full, frank, and open in providing the necessary information to enable the creditor to make an informed decision. 8. A rigid institutional policy of rejecting offers to secure could be a relevant consideration, since the reasonable hypothetical creditor was obliged to consider an offer on its merits. Coherent in-house policies, however, are not necessarily wrong. 9. The creditor is entitled to have regard to his own interests and is not obliged to take a chance or to show patience or generosity. 10. The costs and resources implications for the creditor are a highly material consideration, unquote. I am content to approve that summary as a correct statement of principle. The ninth of these principles is pertinent to the present case. It is based on the judgment of Robert Walker J in IRC and a debtor, 1995 BCC 971, and that of Henderson J in Ross and HMRC, 2010 EWHC 13 Chancery, 2010 2 All England Reports 126. In my judgment, it is a sound point. Mr. Howell's evidence was that his aunt died in May 2018. His evidence was that he was entitled to 1/4 of her residuary estate. That consists primarily of the proceeds of sale of her house. There is no evidence of the grant of probate, although in a witness statement made on the 1st of August 2018, wrongly dated 2017, Mr. Howell said that probate was expected before the 1st of December 2018. In a subsequent witness statement, he said that probate was expected by mid-December 2018 or thereabouts. It does appear from later material that probate was granted, although we do not know when. In his witness statement of the 5th of December 2018, Mr. Howell offered to pay £15,000 forthwith and a further £15,000, quote, on imminent closure of estate accounts, unquote. He had given what were described as, quote, irrevocable instructions, unquote, to the executor's solicitors to pay all sums which he was due to receive from the estate to Mr. and Mrs. Hughes' solicitors. It is those instructions that are said to amount to security over Mr. Howell's property. In his order of the 20th of December 2018, Deputy ICC Judge Schaffer recorded that those instructions had been given and that Mr. Howell had also given irrevocable authority to Mr. and Mrs. Hughes' solicitors to receive Mr. Howell's share of the estate. He ordered that Mr. and Mrs. Hughes were entitled to receive any interim or final payment out of the estate that would otherwise be payable to Mr. Howell. Mr. Howell was wrong about his entitlement to his aunt's residuary estate. His will named 5 residuary beneficiaries rather than 4, as the executors confirmed in an email of the 21st of March 2019. It follows that all his calculations about what the value of his inheritance might turn out to be were wrong. So far as the value of the residuary estate is concerned, Mr. Howell's aunt's house was put on the market at £225,000, but the executors stated in that same email that there was no interest at that price, and the asking price would be dropped to £215,000. The garage was to be sold separately for £16,000. On that basis, even if no expenses were deducted, Mr. Howell's maximum entitlement would be £46,200. That contrasts with the figures which Mr. Howell gave, at least £60,000 in his witness statement of the 1st of August 2017, an asking price of £240,000 plus the garage at £16,000 in his witness statements of the 5th of December 2018 and the 10th of December 2018. None of those figures were the subject of any expert evidence. By the time that the petition came before ICC Judge Burton on the 21st of March 2019, there was still no offer for the house on the table. In their email of the 21st of March 2019, the executor's solicitors explained that the market was slow and that it was not possible to give an indication when an acceptable offer would be received, although they hoped for one within the following month. But they did say that completion generally takes place 8 to 9 weeks after a sale is agreed, and that distribution would take approximately 4 weeks after that. The evidence, such as it is that the estate of Mr. Howell's late aunt is still in the course of administration, although we were informed that the house was sold in early 2021, some 2 years after ICC Judge Burton's decision. The law on the rights of a residuary beneficiary in an estate in the course of administration was clearly stated by Viscount Radcliffe in Commissioner of Stamp Duties Queensland and Livingston, 1965 AC 694. First, when property came to an executor by virtue of his office, it came to him in full ownership, without distinction between legal and equitable interests. The whole property was his. He held it for the purpose of carrying out the functions and duties of administration, not for his own benefit, and those duties would be enforced upon him by a court of chancery. Second, equity did not recognise or create for residuary legatees a beneficial interest in the assets in the executor's hands during the course of administration. The principal right of a residuary beneficiary is a right to compel the due administration of the estate. This statement of principle has never been doubted. Thus, in Marshall and Carr, 1995 1 AC 148, Lord Brown-Wilkinson said, quote, "In English law, the rights of a testamentary legatee in the unadministered estate of a testator are well settled. See Lord Sudeley and Attorney General, 1897 AC 11, and Commissioner of Stamp Duties Queensland and Livingston, 1965 AC 694, ... A legatee's right is to have the estate duly administered by the personal representatives in accordance with the law, but during the period of administration, the legatee has no legal or equitable interest in the assets comprised in the estate. In addition to a right to compel the due administration of the estate, a residuary beneficiary also has an immediate entitlement, arising from the terms of the will, to have transferred to him, at the completion of the administration of the estate, such assets, if any, as then form the residue of the estate. Dr. Barnardo's Homes National Incorporated Association and Commissioners for Special Purposes of the Income Tax Acts, 1921 2 AC 1, Lee's Will Trusts, Handyside and Durbridge, 1970, Chancery 277. Nevertheless, the definition of property in section 4351 of the Insolvency Act is extremely widely drawn and includes, amongst other things, choses in action. Thus, it has been held that the right of a residuary beneficiary to compel due administration of an estate falls within that definition, with the consequence that that right forms part of the bankrupt's estate. Re Hemming, 2008 EWHC 2731 Chancery, 2009 Chancery 313. Since the right is a transmissible right, it is capable, at least in theory, of being the subject matter of security. In Roddick and Gandel, 1851, 1 to G.M. and G. 763, Lord Truro LC considered how a chose in action might be secured and formulated the principle as follows, quote, "An agreement between a debtor and a creditor that the debt owing shall be paid out of a specific fund coming to the debtor, or an order given by a debtor to his creditor upon a person owing money or holding funds belonging to the giver of the order, directing such person to pay such funds to the creditor, will create a valid equitable charge upon such fund. In other words, will operate as an equitable assignment of the debts or fund to which the order refers," unquote. The Privy Council approved that formulation in Palmer and Carey, 1926 AC 703. In the present case, Mr. Howell agreed with Mr. and Mrs. Hughes that part of the debt owing would be paid out of a specific fund coming to Mr. Howell, i.e. his share in his aunt's residuary estate, and directed the executors to pay those funds to the Hughes solicitors. I am prepared to accept that that amounted to securing that part of the debt for the purposes of the Insolvency Act 1986. Thus, the appeal proceeded on the basis that whatever Mr. Howell's ultimate interest in the proceeds of sale of his aunt's house turned out to be, his right to those proceeds was secured in favour of Mr. and Mrs. Hughes. Nevertheless, it was an unusual kind of security. It was not a security over immediately realisable property. Its value would depend on how much was received from Mr. Howell's aunt's house and when. The uncertainty relating to both the value and timing of the security would undoubtedly be something that the hypothetical creditor would bear in mind. Deputy ICC Judge Schaffer made precisely these points when the petition came before him on the 20th and 21st of June 2018, in concluding that at least at that time the offer had not been unreasonably refused. 9 months later, when the petition came before ICC Judge Burton, these uncertainties had still not been resolved. In the course of his oral submissions to the judge, Mr. Howell said that he anticipated that there could be a shortfall between the petition debt and the realised share of his aunt's estate. What he said was this: I anticipated there could be a shortfall, and for that reason I was going to pay £10,000 by the end of the month, because I mainly get money towards the end of the month. I have got 3 different accounts, so I totted them up. At the moment I have got less than £5,000, but by the end of the week I will have 10,000 in anticipation that some of that may have to come back to me, but obviously that was the original concept anyway, so I don't have a problem with that, and if someone thought it ought to be more than £10,000, then I would go along with that, but at the moment it seems to me that £10,000 would be more than adequate, unquote. At 13, ICC Judge Burton made the same points about uncertainty that Deputy ICC Judge Shaffer had made, which led her to the conclusion that the debt had not been secured. At best, only part of it had been. I do not understand Mr. Howell to challenge that conclusion. It follows, therefore, that the judge was not required to dismiss the petition in accordance with Section 2711A. That led her to consider Section 2713. That section is expressed in discretionary rather than mandatory terms. By that time, over 3 years had elapsed since Mr. and Mrs. Hughes had recovered judgment against Mr. Howell. The judge said at 17 that although it might have seemed at the time when Deputy ICC Judge Shaffer made his order that Mr. Howell's interest in the estate, quote, might soon be realised and in a sufficient amount to discharge the petition debt, unquote, that was no longer the case. She considered that it would be very likely to take at least several months before the value of the shortfall could even be calculated. Mr. Howell's offer to pay the shortfall within days did not provide any clear assurance for the petitioning creditors that the petition debt would be paid within a reasonable period. She concluded, therefore, that Mr. Howell's offer was not one that no reasonable hypothetical creditor could have refused. Accordingly, she made the bankruptcy order. Mr. Howell applied for permission to appeal on 3 grounds. New GJ refused permission on 2 of those grounds, but allowed one, ground 2, to go forward. He explained the point that Mr. Howell wished to argue. That was that there were 2 separate points: whether the offer is one that will lead to the debt being discharged within a reasonable time, and B, the position where part of the debt is secured. The point that Mr. Howell wished to argue was that where part of the debt is secured, it does not matter whether the security can be realised within a reasonable time, because the creditor is protected by the security. Birss J heard the appeal. He rejected Mr. Howell's argument. He said that while the position might be different, where the amount secured gave a surplus over the petition debt, that was not the position in this case. Not only was there a shortfall between the amount secured and the petition debt, but the evidence suggested that the market was falling, with the consequence that what Mr. Howell was offering to pay might well not have been enough to cover the shortfall. In those circumstances, the time that might be taken to realise that the security was relevant, because it was the creditor who bore the risk if it were to turn out that the realised share of the estate at some further time was not enough to cover the shortfall. Mr. Howell also argued that he had offered to pay more if need be, but Birss J said that nothing concrete had been put forward and that the judge was entitled to approach the case in the manner that she did. In order to be an offer for the purposes of Section 271, an offer must be a concrete offer capable of acceptance. It must be a present offer, not the possibility of a future offer. An offer simply to top up the shortfall is, in my judgment, not enough. Nor is it up to the creditors to negotiate with the debtor before the debtor makes an offer. The offer that the debtor makes is one for him to make and him alone. I do not consider that Mr. Howell's vague statement in the course of submissions, unsupported by any credible or objective evidence, that if someone thought that it ought to be more than £10,000, then he would go along with that, amounts to an offer at all. It is certainly not one that no reasonable creditor would refuse. A reasonable creditor is entitled to know where the money is to come from, what other liabilities the debtor has which would need to be satisfied, and when the money would be forthcoming. I can see no error in the way that Birss J dealt with the allegation that an offer exceeding £10,000 had been made. The reason why a petition is liable to be dismissed if the debt is secured is that the security gives the creditor the ability to procure repayment of the debt without recourse to bankruptcy. I reject the submission that if a debt is secured, it does not matter how long the creditor will have to wait before being able to realise the security. Security is only of value if it enables the debt to be paid within a reasonable time. The creditor is not unreasonable in refusing to wait for an indeterminate time, for an indeterminate amount, before the security can be realised. Indeed, in the present case, it is difficult to see how the security could be realised at all. In practice, Mr. and Mrs. Hughes would simply have had to wait until the executors had sold the house, and then either receive an interim distribution, the amount of which was entirely uncertain, or wait until the estate had been administered. Mr. Howell does not have permission to argue any other ground of appeal. I would therefore dismiss the appeal.
I agree.
I also agree. So, Mr. Howell, in those circumstances, your appeal is, I'm afraid, dismissed. Mr. Brown?
My Lords, I'm very grateful. I merely wonder whether your Lordships want to hear from me at all on the written application for an order under the Legal Services Act 2007, Section 194, in respect of the representation that's been provided to the creditors for this appeal.
Right. Where's that application?
It's set out in the skeleton argument.
Yeah. Page?
In the core bundle, my skeleton starts at page 65 and at paragraph 6 on page 66 and over the page.
Sorry, I must be in the wrong place. I'm looking at your updated replacement skeleton argument.
Yes,
Is that correct?
yes, paragraph 6.
The C's position is that there was no misunderstanding by Birss J.
Yes,
Yeah, then you ask for an order
Oh,
under the
sorry.
Legal Services Act 194.
yes. Simply, rather than asking for the respondents' costs themselves, because the respondents...
You're appearing pro bono,
For
presumably?
this hearing, yes. For this appeal, we've dealt with it pro bono.
Yes.
Basically, the respondents have reached the point where they simply could not fund the continuance of the litigation. And that being
And
the case...
what's the payment you seek then? Is that in the cost schedule served this morning?
Yes,
And has that been served on Mr. Howell?
has been sent by email to Mr. Howell.
And looking at that, you're seeking a payment of £13,000.
Yes, but I'm in your Lordship's hands as to a summary assessment of that. It's based on the time that I have spent
At £250 an hour.
at £250 an hour, and that's how the figures are calculated.
I must say, I'm not conscious of having seen questions.
No, well, let me
it's
just tell you
not-
what's on it. I've got it on my screen. It's a draft. Have you got a copy?
I
Could
do
hand
have
up to
a
my
copy,
lord?
yes, I can hand up.
It came in while we were having the hearing. It's one of the benefits of having a screen on one's desk.
It's just a one-off thing. It's not a formal cost schedule because, of course, one couldn't sign the indemnity statement, so it can't be in that form.
I've had the benefit of seeing it. If you could... There's only one, is there? Well, I'm going to let my lord see it, and then I'm going to show
Thank you.
Lord Justice Coulson the thing on my screen. So it's
It's based on the 250.
yeah, and then it's 10 hours drafting the skeleton, updating the chronology, working on the bundle indexes, and then a notional brief fee of £10,000. What do you say, Mr. Howell?
Well, firstly, the normal point about appealing or any application is whether the question is whether you've caused the respondent any cost. I haven't.
Why haven't you?
Well, because they haven't incurred any costs. I mean, it's just a statement of situation.
Yes, well, that's why they drew our attention to the section in the Acts, the Legal Services Act 2007, Section 194, that allows the court, in circumstances where there is a pro bono appearance to order the losing party to make a payment to the Access to Justice Foundation.
Yes, I've read the act.
You understand?
I mean, that bit of the act that was sent to me.
Yeah.
Um,
So why shouldn't we make such an order?
well, the first point is because I haven't caused any cost to be incurred.
I don't understand that point. I mean,
Well,
you've appealed unsuccessfully, and obviously the creditor wants to protect his position, and therefore it's instructed Mr. Brown to come along. The fact that we didn't call on Mr. Brown has nothing to do with it.
Well, that was my second point, the fact that he didn't help the court. But the main point is that when one is successful, then the fact that the opponent has resisted and incurred costs is down to them because they've resisted something which they lost. When they've been successful in resisting it, then the person who's caused them to incur the cost to resist it has to pay, which would be me. But in this case, they haven't incurred a cost, so I don't see.
Well, that's why Section 194, which we can look up, and I see my lord is looking it up, says that we can make this order in those circumstances.
Well, I haven't had a chance to look at the case law about.
Well, let me just tell you what it says. Is it in the bundle?
My lord, no.
Section 194 of the Legal Services Act 2007. Right, so that says payments in respect of pro bono representation. Section applies to proceedings in a civil court. The court may order any person to make a payment to the prescribed charity, which is the one, no doubt, that Mr. Brown seeks, in respect of R's representation of P. In considering whether to make such an order, the court must have regard to, first, whether had R's representation of P not been provided free of charge, it would have ordered the person to make a payment to P in respect of the costs payable by P to R in respect of that representation, which is obviously satisfied here, and if it would, what the terms of the order would have been. The court may not make an order under 3 against a person represented in the proceedings if the person's representation was at all times within subsection 6, and representation is within 6 if provided by a legal representative acting free of charge, or provided under arrangements made for the purposes of Part 1 of the Legal Aid Sentencing and Punishment of Offenders Act. Against a person represented. So if you were represented by somebody acting pro bono, we couldn't make the order. I think that's right. Rules of court may make further provision and provide particular proceedings. The prescribed charity means a charity prescribed by the Lord Chancellor. I think that's all of it, isn't it, Mr. Brown?
My lord, yes, that's the relevant.
Yeah. So that applies, as it seems to me, Mr. Howell.
I heard that rules apply, but I don't know what the rules are.
Well, the rules apply, but the rules, I mean, we can look at those.
I think I heard correctly that the court has to have regard to whether a cost order would have been made. It doesn't say that.
Well, I mean, a cost order would obviously be made when an appeal is dismissed.
Yes, having regard to something doesn't mean that we sort of mimic it or follow it exactly.
No, that's why we're asking you what you say. Why shouldn't we make a costs order in the amount that Mr. Brown seeks?
Well, I've already said that. I'm not going to repeat that. still think it's relevant. I would say that, first of all, I would say that the amount of hours seems excessive, because that's 52 hours. 200
Seems a lot.
Seems a lot.
Yeah, well, that's fair.
I mean, I wish I'd spent that amount of time. I might have done better today. But
Well, that's a fair point. I mean, you say we should make a lesser award.
yes, in the absence of being able to think of any other reason to oppose it, I would say that, yes.
Yeah. Okay. Mr. Byrne.
My Lords, I should probably just draw attention to Rule 46.7 in the CPR, which I think my Lord Justice Lewison has already found, which is when the section talks about rules of court, that is, I believe, the relevant rule. And it effectively provides that it can be no greater than the costs. The amount of any order made under Section 194 could be no greater than the amount of cost.
Well, I should have thought that's pretty obvious.
Well, one would have thought that that would be a fairly obvious principle, but the rule
It
makers
needs to
thought
be
it-
made clear by the rules.
Indeed, and that.
So what do you say about Mr. Howell's submission that you spent an awful lot of time on this, considering it's quite a simple point?
My Lord, it's ended up being a simple point, but one would have seen that there is a tendency for other points to emerge from time to time, but also, my Lord, it's a summary assessment. It can be a summary assessment.
What happens to this money when it goes to the charity?
They use it to provide various services, including representation.
Pro bono services.
Support to pro bono representation.
Support for pro bono representation. I see.
There is indeed actually, within the notes in the White Book, there is a link to the Access to Justice Foundation website where I think they set out some of the things that they do with it.
Not in my electronic copy, there isn't.
Ah.
Should be, that was exactly what you'd expect.
Well, there is in my electronic copy, and I don't know why I should have
okay.
an advantage over your Lordship, but there you
Oh
go.
well, there we are.
Access 5 February 2021 in the hard copy.
Yes, which is not very useful in a hard copy.
No.
Does this include the CLIP scheme? That they finance?
Oh well, thank you very much. Anything, Mr. Howell, anything you want to add?
Well, I mean, I think it's a worthy charity, because I think litigants need help. Access to justice is in a dire state. I know from personal experience. So I'm very much in favour. It's just I don't have much money. So
No, I think we've probably got that point, Mr. Howell. Well, we're going to order that Mr. Howell, you pay £7,500 to the charity within 42 days. Thank you both very much for your arguments.
My Lord, sir, would you benefit from a draft order just with the normal wording?
I'm sure we would. We'd always benefit from a
Always
draft
benefit.
order.
I will take
Mr.
an email
Burton.
address from the...
Thank you very much indeed.
Right.